Good morning, Your Honors.
Good morning.
Sanga Terminal for the appellant, Eddie Gallen. I would request 5 minutes to be reserved for rebuttal, if I may. Okay. Your Honor, this case is on appeal from the trial court's order dismissing the plaintiff's complaint with prejudice. And the complaint alleged 3 counts. The first count was a negligent misrepresentation. The second count was promissory estoppel, and the third count was a negligent procurement count. I think before we delve into the legal and factual reasons for the court's dismissal of the complaint, I would like to provide a brief background regarding the facts that gave rise to the complaint itself. In roughly 2006, Natalie Gallen, Eddie Gallen's mother, because Eddie Gallen was a minor at the time, purchased uninsured motorist coverage from Geico. At that point in time, she did not select uninsured motorist coverage and had never had it prior to purchasing that insurance from Geico in 2006.
She had a prior policy that lapsed, apparently?
She did have a prior policy, but she did not have uninsured motorists with Geico on that prior policy.
Both of these cars? Was that policy also on 2 cars?
Yes, Your Honor. Yes,
Okay.
Your Honor. Right. When she got the new deck sheet for the new policy in 2006, she noticed that she was now being paid. She was being charged for stacked insurance on 2 vehicles. So as someone who gets a new insurance policy typically does, she called Geico and says, I don't understand what this means. Can you explain it to me, what the benefits of it, so I can make a decision whether I want to keep it or not? As she testified, although that's not relevant for purposes of today's hearing, the answer she got was, it's called stacked insurance. So if you or your family is involved in an accident, we multiply the number of vehicles by the listed policy limits on your deck sheet, and you will have that amount of coverage. So in this instance, you have 2 cars, you multiply 50 times 100, you would have that amount of available insurance. That specific policy was renewed 3 separate occasions in 6-month intervals prior to the subject accident in this case.
Was there ever a premium charged for the UM coverage on vehicle number 1?
There was a premium charge for 1 vehicle, but not the other.
Okay.
All right. When the
premium charge was for stacked coverage.
For stacked coverage, correct, Your Honor. When the accident happened, Eddie Young, who was still a minor at the time, his mom filed a claim on his behalf with Geico, the insurance company. Geico wrote back and said, although you're paying for stacked coverage, actually you only get the benefit of $5,100, not the $100,200 that she thought that she was going to get the benefit of. At that point in time, we filed a lawsuit. There have been 3 or 4 amendments since. Judge Self at the trial court level made a decision that as a matter of law, that if there a contract is in existence, you cannot have justifiable reliance on something that an agent told you either prior to entering the contract or once you're actually a party to the contract.
Did your client testify that had she known about this, she would have paid the extra $100 or so?
There's an affidavit to that effect, Your Honor.
Okay.
Yes. So as a matter of law, we could not proceed with the case because Judge Self felt, based on the Zarella decision, which is a federal court decision, that there was no justifiable reliance for either the negligent misrepresentation or the promissory estoppel.
What case was Judge Self relying on as authority for that?
It was the Zarella opinion, Your Honor.
And he was not bound by the Warren or the Martin or the Romo cases from the other DCAs?
I think it would have been more persuasive, but I don't, since there was no second district opinion on point, I think that you probably should have considered those.
I mean, do you agree Zarella supports his ruling?
I'm not fully convinced that Zarella is on all fours with regards to the ruling Judge Self made.
Well, because let me ask you a question. If I'm sitting there and someone calls me on the phone, I'm working for Geico, and they say, what does all this mean? And I give them a bad explanation, what would the company have been able to do differently to protect the fact that they don't want their agent to erroneously offer or create coverage in essence? What could they have done different than what happened in this case, except issue the policy correctly saying what the person actually paid for and asked for?
I think 2 things, Your Honor. I think 1, they actually should have done that if that was the explanation they were given, because that's their job. Secondly, if the company is going to offer an insurance product and is going to offer it through agents, and it's their duty and obligation to make sure the explanation they give to their potential customers or insureds correctly reflects the policy they're actually issuing to the insured. It's not, if insurance policies aren't a very straightforward document in all instances. Sometimes it takes the agent of the insurance company to explain exactly the nuances of what policies actually being provided to the insured and what benefits are going to be provided to the insured. That's their job. So my client should be able to rely upon those representations for an explanation of what the coverages are. If they give an incorrect explanation, as they've done here, then I think my client at that point is entitled to pursue a claim for either negligent misrepresentation, fraudulent inducement, promissory estoppel. That's why those causes of action exist when instances like this occur.
Was there any underwriter or similar person that testified about why the word stacked appeared on the deck page?
No, Your Honor. I mean, there was an explanation of the process. There was an explanation of the coverages, but not an explanation of why it appeared the way it does.
Just looking at this policy, this parent policy is very unusual in that one car has liability coverage and the other car doesn't.
Correct.
So somebody decided they didn't need a rejection form because there was no liability coverage on vehicle 1.
That would be our
The
understanding.
default deck page will be the one for no rejection form, which would be the stacked as compared to the non-stacked deck page.
Correct. That would be our understanding, Your Honor. And I think where, to be honest with you, I think where Judge Self kind of got confused with regards to the deck page is that he thought that if it was an actual stacked coverage, the indicated policy limits would be different. It would be 100, 200 as opposed to 5100. That's not the case. If it was correctly stacked, the policy limits would still show 5100, but we just do the math. In this case,
Because this policy does not stack vehicle 1 and vehicle 2, it only, and I'm not sure that stacked is even the right word, it would provide UM to this family if they happen to be in another vehicle that also has its own UM coverage.
that was the explanation given at the trial court level, but I've researched that issue. I've not been able to find a case that clearly articulates that explanation.
That it would really stack.
Correct, correct.
We used to not call that stacking, we called it something else, but I
Okay.
think, yeah.
Right, but I mean, in essence, what they paid for was, I can't identify either in the contract itself that explains via an example that would actually occur, or a case that says that in this event, this is how the stack would apply.
Another policy.
Correct. So,
And I mean, I'm assuming, but maybe I'm assuming incorrectly. It's stacked costs more than unstacked.
correct. There's a,
Premium charge for stacked versus unstacked.
correct, Your Honor. Correct. So with regards to the appellee's brief in response to our motion, they raise essentially three different arguments. The first argument is, in essence, that the order issued by the trial court was not a final order subject to be appealed to the second DCA. And as a basis for that argument, they cite a third district case that essentially says, in order for the motion to dismiss to be a final appealable order, it must say two things. It must say that the complaint failed to state a cause of action, and secondly, leave to amend has been denied. I would disagree with that on two fronts. One, that third DCA decision actually does not say that. What the third DCA decision says, which is a Grimes decision found at 388 Southern 2nd, 1281, is that if a complaint is dismissed,
This complaint, the order has an odd title, but in the language of the order, it says that the Fourth Amendment complaint is dismissed with prejudice.
correct, Your Honor, correct.
And in this district, that's good enough.
So I'll quickly move on from that argument, taking that clue. All right, so get to the substance of the argument, Your Honor, which boils down to whether or not a plaintiff can have justifiable reliance from an agent that makes representations that turn out to be incorrect about coverages. Their position is you cannot, because it contradicts the written agreement. Our position, based upon the Florida Supreme Court decision in HTP Limited versus Linus Herreras, is that you can, because that's how the cause of action for negligent misrepresentation, promissory estoppel, has been founded. And in that decision, which is a 1996 decision, the court went on to hold that where a contract exists, a tort action will lie for either intentional or negligent acts considered to be independent from acts that breach the contract. A right of action on a contract and for fraud in inducing plaintiff to enter into such contract may exist at the same time, and a recovery on one of the causes will not bar a subsequent action on the other. The courts of many states have recognized the rule that a suit on a contract and a suit for fraud in inducing the contract are two different causes of action with separate and consistent remedies. And the court went on to say that we agree with this analysis. So the Supreme Court has already laid out for at least the last 10 to 15 years that these causes of actions are recognized in the context of an insurance contract. I think the best case that illustrates exactly the fact pattern we have here, and what I'm suggesting this court should follow, is the Romo versus Amedex Insurance Company case. That's found at 930 Southern 2nd 643. In that case, the Romos purchased a health insurance policy from an insurance company and an agent. At some point, the insurance agent made certain representations that they could reduce their monthly premium if they made certain changes to the policy, but a lot of the main benefits that they wanted would remain the same. There were several renewals later, just like in this case, there were several renewals later, and then Romos filed a claim. The insurance company denied the claim, insisting that the coverages that the agent had represented to them weren't in fact provided in the policy that had been issued. So the Romos, like I did, filed a count for negligent misrepresentation, promissory estoppel, and negligent procurement. The holding that I think that was important in that case and is important in this case, the court held that, we specifically held that the terms of a written application do not preclude an action against the insurer and its agent where the agent misrepresents the coverage of the insurance contract and the insured reasonably relies thereupon to his detriment, and that issues regarding the existence of an agency relationship and reliance on misrepresentation of fact are questions of fact. So its opposition is twofold. One, the contract itself does not preclude this cause of action according to both the HTP limited case and the third DCA. And two, the questions that Judge Self ruled upon at the trial court level are more properly questions of fact for the jury. So as long as the allegations of the complaint have been pled sufficiently, I see no reason why we shouldn't have been able to proceed on the trial court level with our cause of action. The court further held, and I know this was an argument directly raised, but I think it's important, that a merger or integration clause which purports to make oral agreements not incorporated into the written contract unenforceable does not affect all representations which are alleged to have fraudulently induced a person to enter into the agreement. So regardless of the nature of the contract, which seeks to disavow the plaintiff's ability to hold those agents accountable for misrepresentations that may influence their decision whether to pay a higher premium, monthly premium for coverages, it doesn't matter. If my client is alleged of misrepresentation and has been pled clearly in the complaint, we should be allowed to proceed with the cause of action. Lastly, reading from the decisions, Your Honor, it said the issue of whether the Romo's reliance on the representations allegedly made by Martinez was reasonable is an issue of fact which may not be resolved at this stage of the proceeding. So our position, in short, Your Honor, is simple. If the complaint is sufficiently articulated, these three causes of action, which we believe they did, but I don't believe Judge Self actually got to the heart of that matter, then we have legal causes of action that should not have been judged or dismissed as a matter of law at the trial court level. One of the defense counsel's other arguments with regards to the negligent procurement count is that there was count nullification. Essentially what they're arguing is that there were earlier counts in the complaint which alleged that Ms. Gallon was unilaterally placed with uninsured motorist coverage, which are counts 5, 9, and 10, and then later on in count 26, we allege that she requested this specific coverage. That's not true. If you look at the specific allegations in all four counts, nowhere in any of those counts do we say that Ms. Gallon requested or asked for the insurance coverages. And I've laid that out in the brief kind of in a table summary format so you can compare the language. The language in the count is completely consistent with our theory of fault against the insurance company. Lastly, they allege that the contract itself, the language of the contract contradicts the allegations in the complaint. It should. If it didn't, this would not be a negligent misrepresentation. It would not be a promissory estoppel, because the basis or the agreement for those counts is that you told us something that existed in this policy. We've now looked at the policy when we needed to make a claim, and it does not exist. So by default, the two should conflict. But we're making an allegation or a request for recovery for a matter outside of the contract itself, so it shouldn't matter. So in essence, summary, Your Honor, our position is the trial court respectfully got it wrong. The cause of action for negligent misrepresentation, promissory estoppel, are not questions that should be answered at the motion to dismiss stage. They should be answered at the fact-finding stage, either summary judgment or at the trial court level. And with regards to the nullification issue, Your Honor, we believe the complaint speaks for itself in its clarity, and we believe that the contract being inopposite has nothing at all to do with the viability of these causes of action.
Thank you.
Good morning, Your Honor. Your Honors, my name is Meredith Stevens, and I'm here on behalf of Geico Insurance Company. I'd like to start today, Your Honor, with the most important argument today, which is that no relief is available to the appellant in this case. Reversal of the trial court's dismissal of the fourth amended complaint would be futile because no relief is available.
Because of why?
Because after the original complaint was filed, Geico filed a counterclaim to the complaint. And in the counterclaim, Geico sought a declaratory judgment as to what the policy limits were in this particular case. And they sought a declaratory judgment that the policy limits were indeed 50, 100, as opposed to 100, 200, as the plaintiff here alleges. Final summary judgment was entered on that issue, and the judgment was rendered on October 21st, 2010.
And could Eddie Gallen appeal that order at that point in time?
No, Your Honor. There was no appeal made. So,
no, I said, could he have?
Oh, could he have appealed? Well, it was a final judgment, so he could have appealed.
Was he dismissed from the action?
Eddie Gallen?
Yes.
No, Your Honor, I don't believe so.
And was the theory in the counterclaim interrelated to the theory in his own claim?
The theory in the counterclaim was merely as to the issue of policy limits.
Which was what the front end was about as well.
Well, which is the basis of the whole claim. The basis of the whole claim is entitlement.
So this was a partial final judgment on a matter factually interrelated with the plaintiff's complaint?
Yes, Your Honor.
Okay, then therefore, under 9.110K, it's not appealable at that time. The first time that Eddie Gallen could appeal that was now.
Okay.
So your argument on that is just wrong.
Okay.
It's esoteric. It's an esoteric appellate matter.
Okay.
Don't feel dumb.
Okay. Well, Your Honor.
Mendez trap.
Right.
Okay.
It's known as.
Okay. Well, then let me move on to my second argument. The second argument is the fourth amended complaint was properly dismissed with prejudice because the complaint fails to state a cause of action. It failed to state a cause of action. The first allegation that I'll come to is the allegation about negligent misrepresentation, which kind of goes along with the allegation regarding promissory estoppel.
And what does the claim for negligent misrepresentation not allege that it needed to allege to state a cause of action?
What it does not allege is justifiable reliance. And the justifiable reliance issue is the issue that was addressed in the Zarella case, which Your Honors discussed previously. In that case, plaintiff purchased policies of life insurance. In language of the life insurance, specifically disclaimed any promises of future tax benefits. So,
but paragraph 18 is entitled Justifiable Reliance and alleges, as a result of Natalie Gallen's justifiable reliance on defendant's material misrepresentation, only when Natalie made application for the insurance benefits after her son's injuries was she told that she was not entitled to full benefits. Why isn't that, from a pleading standpoint, sufficient?
From a pleading standpoint, it's insufficient because justifiable reliance is a matter of law under the Zarella case. The Zarella case was a motion to dismiss, not a motion for summary judgment. And it held that, as a matter of law, reliance on a fraudulent misrepresentation is unreasonable where the alleged misrepresentation contradicts the express terms of the ensuing written agreement.
Okay, well, let's take a look at your insurance policy. Okay?
Okay.
This policy is unusual from my experience because
okay. May I grab the declaration page?
Absolutely.
Thank you.
What's happened here is you've issued a policy that's got liability and for that matter, comprehensive collision on vehicle 2, but you have basically minimum limits on vehicle 1.
That's
so
correct.
whoever the agent was decided they didn't need a selection rejection form because there wasn't any liability coverage on this thing. And because there wasn't a selection form, someone didn't use the non-stacked deck page. They used the stacked deck page because they didn't have that rejection form. So you have a policy that on its face, on its deck page, says it's stacked, but then doesn't charge a premium that I would understand, but maybe a layperson wouldn't understand about this. So the policy says it's stacked, but it's not.
Well, Your Honor, may I address the issue of stacked
Yes.
coverage? In this case, stacked coverage does provide a benefit.
What does stacked mean?
Stacked means that if you have two policies for which and you're paying for bodily injury insurance on both policies, and you're involved in a collision, the coverage will stack. So that way,
So how did this policy stack?
Well, the policy doesn't stack because there was no second vehicle to stack.
But it says it stacks, right there.
Well,
on
yes, but let me explain, Your Honor, if I could. Stacking provides a benefit because if you have stacking benefits, even if you're not in the car for which UN benefits apply, you're still entitled to those benefits. So, for example, if I was in a different car to which the UN benefits didn't apply, wasn't paying the UN benefits for,
Right.
and I was involved in a collision, I would still be entitled to the UN benefits.
Is that what we call stacking, though?
Well, I think that's one interpretation of stacking. I mean, that's what he would have been entitled to if you were in
go to the selection form, some of the alternate options these days allow you to opt out of this part and that part. But stacking historically has been you've got two cars on the policy, and if you pay a premium on both, you get double coverage.
Yes, Your Honor, and that's...
And this says it's stacked, but
Well-
it apparently isn't.
Well,
And-
Your Honor-
And someone told her that it was stacked.
Well, Your Honor, and again, I think we go back to the definition of stacked, and there's a case on point on this that I did not address in my brief because I didn't know it was going to be an issue, but the case is called Swan versus State Farm, and it's found at 60 SO 3D 514. And that case explains that stacked coverage is a benefit, even if there's not two vehicles on the policy, because of the reason that you still get benefits if you're not in the vehicle that the coverage was applied to. So it was still stacked coverage.
If a policy issues when one vehicle, and it just says uninsured motorist coverage, and it doesn't say stacked or unstacked, if I am a pedestrian and I get hit by a car, do I get that coverage? Yes.
If you're a pedestrian and you get hit by the car.
And if I'm in somebody else's car and I get in an accident, do I get this coverage?
If it's stacked?
No, if it just says uninsured motorist coverage. But
I don't know the answer to that, Your Honor.
the answer is yes.
Okay.
And you get it, and if the other car has UM coverage, you get both of those policies. That's not stacking, that's just operation of law for paying a single premium. Stacking is when you pay two premiums and you end up getting double coverage for both of the things I just described.
Well, respectfully, Your Honor, that's exactly what the Swan case discusses. It discusses an issue where the plaintiffs were confused
But
about...
didn't your, according to the allegations at least, your agent get it wrong when he explained it to this woman?
According to the allegations, but, Your Honor, we go back to an argument that I will make later, which is that the allegations in the complaint conflict with one another and the terms of the contract and render it null and void on its face.
In civil cases, you can only plead consistent causes of action.
Well, when they are incorporated into one another, and that is the case we have here. When the allegations are incorporated into other allegations and the allegations conflict with one another and the terms of the insurance contract, which is part of the complaint, they render the allegations null on their face. And that's what we would get to later when we're talking about the negligent procurement claim. But the important point is here that the oral representations that were allegedly made by the GEICO agent conflicted with the express terms of the written agreement. This written agreement was in place when Ms. Gallen allegedly made the call. The
express agreement on its face says it's stacked on the deck page.
Your Honor, it does say stacked on the deck page. The deck page does say stacked.
Right.
So
it doesn't, what he said didn't really conflict with the deck page.
Well, that's exactly my point, Your Honor, is that...
The deck page conflicts with the body of your insurance policy. I bet.
Well, there was no allegation that the declaration page conflicted with the body of the insurance policy.
Well, then good, then it's stacked insurance coverage.
And again, Your Honor, I would go back to the issue that it is stacked. There was just no second vehicle to stack, and you still get the benefit of stacking from that. So
a two-story building is a one-story building without a second story?
Well, if you don't pay, and that's what Judge Wright addressed in the motion.
If you don't build the second story, it's still a two-story building.
Well, if you're not paying for the second story, then you have nothing to stack. And that's the issue that Judge Wright addressed when she rendered the summary judgment motion, and I know we've baited that argument about whether there's relief available. But that is what she decided, that since there was no money being paid for coverage on the second vehicle, then there was no entitlement to the additional UM benefits. Now, if I may, Your Honor, turn to the issue of the abuse of privilege in this case, and I will only stay on that for a moment. But plaintiff's counsel has amended this complaint several times in an attempt to state a cause of action. And the cases I've cited here basically indicate that there's an abuse of the privilege of amendment after.
He chose not to amend it.
Well, he chose not to amend it for the 5th time. That's correct, Your Honor.
He wanted to get an order of finality and file his appeal.
Sure.
So
But
he wasn't asking for the ability to amend the 5th time.
well, sure, but these cases say that you only get 3 attempts. So if this case were to be reversed and sent back down, obviously there would have to be a 5th amendment in order for him to proceed.
And the law says thou shalt never get a 5th amendment.
No, the law doesn't say thou shalt never, but the law
And
says.
this complaint wasn't dismissed for abusive pleading, it was dismissed for failure to state a cause
And
of
I
action.
completely agree with that, Your Honor. But the point is here is that plaintiff has made many, many attempts to state a cause of action here and has been dismissed time and time and time again. And a disorganized assortment of allegations in a hope that a legal premise will somehow materialize is an abuse of the court's time. And if this 4th amended complaint were to be reversed, then he would try to go back and amend another time. And that would be an abuse of the privilege of amendment.
Pretty organized. His pleadings are organized.
Well,
You're saying it's a disorganized set of allegations. I know that's a great analogy, but he's got it organized into various counts. Either it states a cause of action or it doesn't.
Okay.
He's not asking for leave to amend it. I don't think sending it back for leave to amend is one of the options. Either we send it back, try the case, he states the cause of action, or Geico wins as a matter of law.
okay, Your Honor. Well, then let's go back to some of the allegations, and let me talk about how the allegations are inconsistent with one another and also inconsistent with the contract, which is incorporated into the complaint. Plaintiff alleges that Ms. Gallen never intended to make any changes to her policy and that Geico unilaterally added stacked coverage to her policy. But then, plaintiff also alleges that Ms. Gallen contended at the time the policy was renewed, she requested that her policy limits be increased from 100 to 200, and Geico agreed to provide the coverage. So these allegations are inconsistent with each other. If she never intended to make any changes to her policy, she couldn't have been requesting the increased coverage. If she didn't request the increased coverage, then Geico had no duty to procure that increased coverage for her. So those allegations are inconsistent with one another. Additionally, those allegations are inconsistent with the contract, which specifically states that the policy limits are only $5,100, and the allegations of the complaint contrast with that. Ms. Gallen received the policy renewals on 3 or 4 times after this alleged misrepresentation was made. She continued to see that the policy limits were $5,100, $5,100, $5,100. And this was after the negligent misrepresentation was allegedly made. So at no time did she pay for the additional benefits that she's now seeking to be entitled to. Now, there was one other issue addressed in plaintiff's brief that I want to touch on briefly, and that's that former counsel for Geico went outside the 4 corners of the complaint and that Judge Self went outside the 4 corners of the complaint in rendering a decision on the motion to dismiss. And I will admit that former counsel did cite to Ms. Gallen's testimony when he was making an argument regarding the motion to dismiss. However, I would submit to the court that Judge Self did not rely on this testimony in making his ruling. Instead, he relied on the Zarella case, which clearly states that a motion to dismiss is warranted when the face of the contract conflicts with the alleged negligent misrepresentations, where the face of the contract clearly states one thing and then the oral representation that was allegedly made is a different thing. Judge Self indicated that the negligent procurement count was just an attempt to state the other counts, counts 1 and 2 for negligent misrepresentation and promissory estoppel differently. And that is what he ruled defeated justifiable reliance under the Zarella case. So even though that was cited in the motion to dismiss, it was not actually relied on.
Help me with the Zarella analogy, because the policy ensued in Zarella, the negligent misrepresentation. Here, we had the representations made after the fact. The policy's issued.
Yes, Your Honor.
Tell me why should we follow Zarella if it's factually different?
Well, I think that it's factually better for us that the policy was already in Ms. Gallen's hand when she made this.
Well,
there was no
she calls and she believes I'm looking at a tulip. She calls the agent. He says that's a rose, but it really is a tulip. She really was looking at what she thought she had, but she's told it's something else. Is that negligent misrepresentation?
I don't believe it is negligent misrepresentation, again, under the Zarella case,
So the
because...
insurance agent can give her an incorrect representation of what her coverage is, answer that question, and yet not be held liable for the incorrect information.
Well, the agent explained that she had a stacked coverage. The allegation is that the agent incorrectly explained what stacked coverage meant.
Correct.
So under the ruling in Zarella, the answer to your question is yes. If there's a contract that explicitly states what the contract terms are, and it is renewed on multiple occasions, then it is unreasonable as a matter of law when the representations contradict the express terms of the ensuing written agreement to rely on that. And that is what happened here. There was a written agreement which was renewed on multiple occasions, and the express terms were in conflict with the alleged oral representations of the GEICO agent,
I can understand unreasonable as a matter of law, that I get a bad explanation, then I get the policy, it says something different than the explanation, because the last word is the policy, and I neglect to call to get an explanation. But when the policy comes in, and I call, and you tell me it's something different than what the policy says, why is that unreasonable? You're saying as a matter of law, normally that's a factual dispute, and you get to argue the case to the judge or jury. Well, that's what those other cases out the other DCAs say. That's a factual dispute. You can't go outside the four corners of the pleading. It's a moving target as to what is reasonable or unreasonable, and her relying on that in spite of the fact it's right in front of her, believing somebody else who is allegedly in a superior position to explain it, then she would be to understand it.
Well, that is what the Zarella case, and that's why I keep coming back to the Zarella case, stated that reliance is a matter of law.
Before the fact misrepresentation, that's my hang-up.
Can you tell me where in your insurance policy it discusses stacking?
I couldn't cite you to a page number, Your Honor.
I looked, I couldn't find it.
I'm just looking right now, and I realize that in the limits of liability for UM and at least the family auto policy, the main chunk, it really doesn't discuss stacking at all. It looks like a non-stacked policy when you look at that language. And I don't know whether there's a separate Florida section that explains stacking, but there doesn't seem to be an explanation of stacking in this policy.
Well, I can't address that because I don't have the page number of the policy. But again, I will go back to the express language of the declarations page, which Ms. Gowan had the opportunity to review over and over again. And
stacked.
Yes, Your Honor. And and again, I will go back to stacked is a benefit to Ms. Gowan in the ways I've explained before, that she's in a different car and that she's...
but what has happened, though, is she called the agent and says, what does that mean? And so, Swan, I just looked at Swan, and it does provide, well, if you're... there is a benefit, at least Swan Court says so.
Yes, Your Honor.
But that's not what she was told it meant when she called. She was told something else.
Yes, Your Honor.
And I guess the question is what is inconsistent about it? Where in the policy is there something that said that it's inconsistent with what was told to her?
I'm sorry, where in the policy
Is there language that is inconsistent with what was told?
Well, Ms. Gowan is alleging that she was told or that she asked for policy limits of 100, 200, and the policy clearly on its face provides for limits of 50, 100.
No, my understanding, she was told that stack meant that you would multiply that by the number of cars you got.
Yes, Your Honor.
So that she wasn't asking for increased policy limits. She was told that she would get double the UM coverage if it was stacked.
Well, Your Honor, I would cite you to a portion of the policy, and I can't give you the page number, but I have it written down here, where it says that the policy does not provide bodily injury liability insurance for any coverage for which a specific premium charge is not shown on the declarations page. So from that portion, Ms. Gowan should have known that if the bodily injury liability coverage wasn't shown on the declarations page, then she wouldn't be entitled to UM coverage on that vehicle, and then it would not stack with that vehicle.
She's supposed to know that she has to have bodily liability before she gets UM.
I don't want to speculate as to what Ms. Gallen should or shouldn't know. I know that there's a lot of confusion with the insurance contracts, but I, urge Your Honor to consider what kind of havoc would result if any time that people got an insurance contract and they misunderstood the language, they could just allege that they talked to some agent and told them that.
Isn't that a matter of proof? Maybe that never happened. Maybe she's just saying
Well,
that
sure,
because
and I
it's
know
a
we-
horrendous injury. But that's a factual dispute.
Well,
There'd be phone records to corroborate or not corroborate, or maybe that every time you call, there's this thing that says, this may be recorded. So maybe there's a recording.
sure, and I'm completely willing to concede that I have to accept the allegations as true, and I am doing that for the purposes of this motion to dismiss.
Well, but you're here. You won the motion to dismiss below.
Well, sure, I'm
The court didn't accept those allegations as true.
Well, the court accepted the allegations as true, but they found that justifiable reliance as a matter of law did not exist based on the fact that the alleged oral misrepresentations conflicted with the express written agreement that was in Ms. Gallen's hands.
We've asked you a lot of questions. You're over your time, but I'll give you another 30 seconds or so here to finish up.
Okay, Your Honor, well, I think I've pretty much presented my case to you. I think that the most important elements that we need to think about are the fact that the insurance policy on its face conflicted with the alleged misrepresentations of the GEICO agent, and the fact that the allegations in the complaint regarding whether Ms. Gallen made changes to her policy and whether GEICO unilaterally provided that to her are inconsistent with any allegation that Ms. Gallen requested a increase of her policy limits. So those allegations, and in addition to the language of the contract, render the complaint null because they conflict with one another.
Okay, thank you.
Thank you for your time.
Thank you.
It appears that Your Honors have a very good grasp of the issue, so unless you have any questions for me.
No penalties for quitting early.
That's right. Thank you.
With that, court's adjourned.
Thank you, Your Honor. Thank you for your time. I do.
We didn't see that on camera, though. We didn't see that on camera.
Yeah, that was the case.
Sure you wouldn't do more of this?
All right. I think that's enough for that.
Yeah, no.
Ready to go back to public school purposes.
You all have a good day.
Thank you, you as well.
Hello, Joe.
Hey.
How are you?
Good.
This came to shut down the cameras. Hello, Marshall. How are you?